So to move on to this panel, I'm thrilled to be introducing our moderator today, Professor Kathleen Mahoney, dealing with this Human Rights Commission panel. Professor Mahoney's entire career has been dedicated to advancing human rights in Canada and around the world, and she's been an inspiration and mentor to many in this field and beyond. I can say this with certainty because she was my professor in law school. I took every class that she offered and tried to learn as much from her as I possibly could. But buckle up as I go through her accomplishments because they are lengthy. Kathleen has a JD from the University of British Columbia, an LLM from Cambridge University, and a diploma in International Comparative Human Rights from the Strasbourg International Human Rights Institute in France. She is an emeritus professor of law at the University of Calgary and is, this still says King's Counsel. She was the chief negotiator for Canada's Aboriginal people's claim for cultural genocide against Canada, achieving the largest financial settlement in Canadian history for the mass human rights violation of Indigenous peoples of Canada, and thereby was the primary architect of the Truth and Reconciliation Commission of Canada and led the negotiations for the historic apology from the Canadian Parliament and from Pope Benedict XVI at the Vatican. She was co-counsel for Bosnia-Herzegovina in their genocide action against Serbia in the International Court of Justice, with the result that the definition of genocide in the Genocide Convention was altered to include mass rape and forced pregnancy as genocide offenses. Among her many awards and distinctions, Professor Mahoney is a Fellow of the Royal Society of Canada, King's Counsel, a Trudeau Fellow, and a Fulbright and Human Rights Fellow from Harvard. She received the Governor General's Medal for her contribution to equality in Canada. She's held the visiting professorships of fellowships at Harvard University, University of Chicago, Adelaide University, University of Western Australia. It just keeps going on. And she was recently appointed Raoul Wallenberg Centre for Human Rights Canadian co-chair. So, and she and my father have a long history of working together. Both of them are relentless in their advocacy and in their commitment to this area, and it's a thrill to introduce her today and turn the panel over.
Well, thank you, Corey, for that introduction. My mother couldn't have done better than that. Appreciate it. Needless to say, Corey was one of my favorite students over the years that I've taught many, many hundreds of students at the University of Calgary Faculty of Law. She stood out then and as she stands out now. And of course, her wonderful father, I mean, what a speech. Ron, that was classic. That was fantastic. Talk about tell it like it is. That was really, I'm not going to use the word courageous because Ron, that's just Ron, but it was telling it like it is. And that needs to be done more and more, in my view. And we heard a real historic, very important speech just now. So before I introduce the panel, I really want to thank Ron Gitter and his daughter Corey and his team for putting this together. This just isn't a meeting. This is a historic meeting, in my opinion, because human rights have really languished in this province for far too long. And by having this event here today, I think Ron has injected a certain energy and recognition that it's time. It's time we did something, and it was because of his leadership, which he has shown throughout his career here as a leader in Alberta and a leader in Canada when he was in the Senate. He is taking us to another place. And so I hope everybody in this room senses it the way I do, that this is an important moment. This is a turning point moment. And Ron is leading us in the right direction. So thank you, Ron, for inviting me to play a small role by mediating this important panel. Our panel members are all very distinguished people in the field of human rights, and I'll introduce them in terms of the order in which they will speak. I didn't have a chance to talk to everybody in advance, but I'm just going by the order on the program. First, we have Raj Dhir. Raj has been the Executive Director and Chief Legal Counsel at the Ontario Human Rights Commission for the last 4 years. So he's going to talk about the experiences in Ontario at the Human Rights Commission. Marc-Alain Mallet, he's from the New Brunswick Human Rights Commission, and he's the director there of the Human Rights Commission in New Brunswick. Robert Philp is the former chief commissioner of the tribunals of the Alberta Human Rights Commission. Sorry for pausing there. I didn't mean in any way to suggest that your role is somewhat less. I just couldn't read as I'm aging as well, so I'm off and on with the glasses. And finally, my colleague from the University of Calgary Faculty of Law, Evaristus Oshionebo. Evar is a very important addition to our faculty. The students love him, and he's going to talk about the experiential reality of Human Rights Commission in Alberta. So I thought before we started, and Ron did this to some extent in his speech, I'd just outline the issues that are going to be discussed so that you have them fresh in your mind as our speakers begin. One of the critical issues that they will discuss is the notion of independence, the independence of the Commission from government. So the question is always, when you have some kind of commission or tribunal, is who is pulling the strings? Or is anyone pulling the strings? The problem is when you don't have a fully independent arm's length commission, there's a danger of politicians pulling the strings. Here in Alberta, the Human Rights Commissioner answers to the Minister of Justice. And so the Minister of Justice gets to decide funding for the Commission, gets to decide direction, and so on. Do we want that kind of relationship? Or should the Human Rights Commissioner report to the legislature, which is an all-party body that can call for or demand accountability? So that's a major issue across the country. And Ron identified the Vrend case. What he didn't mention was that the minister interfered in the Vrend case and told the Human Rights Commission not to go forward with the Vrend case. So that is a perfect example of why commissions need to be independent. And Vrend, of course, now is a leading case in Canada and around the world as to the responsibilities of governments to protect their disadvantaged minority members. A second issue that the panel will discuss is the structure of human rights commissions. How are they structured, and what does this have to do with the protection of human rights? There's different models across the country, and we'll hear about those and how they work and why some models are more effective than others. A third issue that hopefully will be canvassed is the activities or the mandate of human rights commissions. Historically, we've always thought of discrimination as bad people doing bad things to individuals and putting the onus on the individual to raise their hand and say, I don't want to put up with this anymore, and I'm going to make you account. So the onus is on them to go to the Human Rights Commission and to complain about discrimination. However, if that person is the member of a group, and all members of that group are experiencing the same thing, whether it be housing or employment, every member of that group has to take their case before the commission in order to get a remedy. That's one model. Another model is looking at the facts of discrimination and the social context of discrimination and seeing whether or not it's something more than one bad person discriminating against. And that's called systemic discrimination. So do the Human Rights Commission models allow for a broader social context view of discrimination, which we call systemic discrimination, as opposed to putting the onus on the individual who's already disadvantaged by definition to take on the legal burden of bringing their case forward. So the activities and mandate are another issue. And finally, the funding. Funding makes the world go round, as we all know. You can't do very much without any money, particularly if your mandate is to solve problems, to get resolutions to these complaints, as well as to educate the public and to advocate for greater protection for human rights. So what level of funding, I'd be very interested to hear from the panelists, are they experiencing in their different jurisdictions, and what a difference does that make? So on those very short introductory remarks, I'd like to start the panel discussion. So Raj, if we could start with you, that'd be great.
Good afternoon, everyone. Human rights commissions are more important now than they've ever been before. In these challenging times, where we see the effects of the twin pandemics, COVID-19 and systemic racism, the proliferation of hate activities, shifting demographics, and competing human rights, we need strong human rights commissions to act and take leadership. And yet, all too often, we see human rights commissions' functional capacity spread too thinly. We see delays in having human rights claims dealt with. And we see gatekeeping that precludes human rights claimants from obtaining access to justice. So what can we do to make human rights systems more effective? How can we ensure that the human rights system is able to respond to the challenges we're facing currently? Which model is the right one to optimize success in addressing systemic discrimination? Are there reforms that we can pursue within our current systems that we should insist on for all human rights institutions that don't necessitate wholesale change? Are there principles that we should look for in all human rights institutions to ensure that they're well positioned to be able to provide human rights leadership nationally, provincially, and territorially? So my name is Raj Dhir. I'm the Executive Director of the Ontario Human Rights Commission. And before we get into these issues, I want to tell you about Ontario's 60-year journey with the human rights system. And it's important to talk about Ontario's experiences, not because we're the center of the universe, we are, but because our experiences have at different times involved the various models and reforms that we're examining today, and can serve to inform, I hope, can serve to inform many of the questions that I raised at the outset. So in this presentation, I'm going to provide a brief history of Ontario's human rights system, mainly through the prism of the Ontario Human Rights Commission, its legislative mandate and current priorities. I want to give you some background into the legislative changes, called it Bill 107, the Human Rights Amendment Act in 2006, that led to Ontario adopting what we call a direct access system, where claimants can go directly to an adjudicative tribunal, and how this system allows for three pillars in Ontario: the Human Rights Commission, the Human Rights Tribunal of Ontario, and the Human Rights Legal Support Centre, which provides support to individual claimants. I will also talk about the Ontario Human Rights Commission's current organizational structure, funding, and outreach, education, and advocacy work in the aftermath of these changes. And finally, I'm going to discuss the strengths and challenges we can continue to face and the opportunities for improvement. So, the Ontario Human Rights Commission is a 61-year-old arm's-length provincial agency, and it's one of three pillars of Ontario's human rights system. Our role is to promote, protect, and advance human rights in Ontario with a focus on systemic discrimination. We have a broad mandate that covers issues across the entire province. All 17 of the prohibited grounds of discrimination, things like race, sex, creed, disability, sexual orientation, etc. And all the social areas, the 5 social areas covered by the code, including private and public services, employment, and housing. However, with a budget of over $5 million and a little over 30 staff to effect a provincial mandate, there's a need to focus our proactive work so we can maximize our reach and impact. And we achieve this focus through our strategic plan, which prioritizes 4 areas: Indigenous reconciliation, criminal justice with a focus on corrections and policing, poverty, and education. We also do this by closely working with what we have established as advisory groups that are comprised of experts and community leaders. The idea is to hear about emerging issues from people on the front lines and to try to address these issues proactively. And finally, there are a lot of ways to affect change, whether it's through the development of a policy, whether it's through education, training, whether it's by conducting a public inquiry or engaging in strategic litigation. We have a variety of tools, and we have to leverage all of these tools and manage our resources in the most effective way. And one final note on this slide that I just want to point out is that we're currently engaged in strategic planning activities this year to create a new strategic plan to anchor the work of the Ontario Commission over the next 3 years. So that's something to stay tuned on. Now, I spoke earlier about the changes in 2006 to the Ontario Human Rights Code, which resulted in 3 pillars. A human rights tribunal offering direct access to human rights claimants, a human rights support centre which provides legal support to claimants, and the Ontario Human Rights Commission, whose mandate was narrowed so that it was no longer required to deal with the investigation and enforcement of individual human rights claims. The theory behind these changes is that this new system will provide claimants with greater and speedier access to justice and allow the Ontario Human Rights Commission to focus on prevention initiatives such as policy guidance, education, and systemic discrimination through public inquiries and strategic litigation. And while all that sounds great, one always needs to look at the operational realities to determine whether the human rights system can deliver on its promise. And that's why we need to look at the organizational structure. The changes to the human rights system in Ontario were made on a cost-neutral basis, which meant that there was simply a redistribution of resources and funding from 2 pillars, the Commission and the Tribunal previously, to the 3 pillars. So they've redistributed those resources across 3 different organizations. For the Commission, this practically resulted in major layoffs, redeployment, and reorganization of its staff. It included eliminating or significantly reducing its mediation, investigation, and legal branches. The Ontario Human Rights Commission's budget was $14.2 million in 2005, and today, in 2022, it's just over $5 million. The Ontario Commission has gone from an organization with 135 staff to an organization of 33 staff, comprising of legal services and inquiries, policy, education, monitoring and outreach, communications and issues management, and corporate services. That's $5 million and 33 staff for a provincial-wide mandate to address systemic discrimination in relation to 17 code grounds and 5 social areas. Now, our mandate remains broad. The functions are set out in Section 29 of the Ontario Human Rights Code and other sections of the Human Rights Code. There are broad powers to forward the policy of anti-discrimination, to promote the Act, to inquire into tension and conflict, to take appropriate action, review laws, encourage public and private organizations to alleviate tensions, to initiate investigations and enforcement of the Act. But the net effect of our operational realities, in conjunction with the breadth of this mandate, has forced us to be a lean machine and to maximize our resources. And we do this in a number of ways. First, we recognize that there's lots of different ways to affect change, and that's what I spoke to earlier about the different tools that you can use. And, there are decisions that have to be made, strategic decisions, where you might say, okay, this systemic issue may call for a public interest inquiry, but that means that I won't be able to do an inquiry into this important policing issue. So maybe I have to address that by making a submission to government, or maybe I have to address that through a community consultation. We have to find ways to leverage all the resources within our organization so that they can act in concert with one another and concurrently to affect as much change as possible and to ensure that our reach is as broad as possible. And we do that. I mean, that's how we function. So we do things like, we had a public inquiry recently, some of you may have heard about it, in relation to we called it the Right to Read inquiry. Students with reading disabilities and how they are being taught to read in the public school system. We engaged in strategic litigation by intervening in a case before the Ontario Court of Appeal, a systemic discrimination case that involved the pay of Ontario midwives, who are predominantly female. So, it was based on gender discrimination. We used our promotion mandate to take leadership on issues of tension and conflict that arose during COVID, things like providing advice relating to mandatory vaccination requirements. We used our education mandate to deliver programs online. So we do some online training, and we have some successful programs that I'll speak to in a moment further about that. We do other things like we use issues and media monitoring to try to stay abreast of emerging human rights issues. So, in all of the things that I've outlined, what I hope you've heard and what I've been able to demonstrate is that we use every part of the tools that we're given, and every one of the branches is engaged by that. Am I already over? 2 minutes. Yeah. Okay, all right. Okay. Well, what's next? Let's see here. Okay, education. How much time would you like me to? How much time do you want? You want me to stop now?
Wrap up. Yeah, no,
I can wrap up?
In 2 minutes.
Okay.
Yeah.
All right. Well, okay. In that case, this slide really outlines some of the public education work, the outreach work that we're doing. You've heard from the amazing panels this morning about how critical that work is, and we have. We're involved in that as well. I think the challenge is, again, we have great examples of online programs, things like Call It Out, which is a race-based public education program. We had 750,000 viewings of that last year in the province, and that was an increase of 140% from the previous year. And we have an accessibility online tool as well that had over 101,000 viewings. And we have a Human Rights 101 program. The point here is if we had more resources, we could look at developing other education programs which could have the same kind of reach and potential. So I think I know I've exhausted my time. So maybe what I'll do is I will reserve this portion of my discussion for the broader discussion that we'll have as panel. Okay? Yeah. All right. Thank you.
Am I on? Yep. Raj, if you would have asked, I would have sold you 5 minutes. So, okay, we'll try to make up time. First, thank you very much, Ron, to your team. This has been fantastic. Magnetic personality. How's that?
That's better.
Better? Okay. Let's try this again. Scary. Does it seem like it's working? Is it working? Yeah. Okay, all right. Ron, again, thank you very much for the invitation and for the hospitality of your team. I'm very envious. I'll start with this. I wish that this type of discussion and collective getting together and trying to figure out how do we go forward would happen in every province. This is also in my jurisdiction, but maybe one day we'll get there. Oh, and I've got control too, that's right. Okay, I want to start with, so I flew from Fredericton yesterday morning. I left around noon or so, and then via Toronto, and then I got here a little bit later on. But I did witness something on the first flight in Fredericton that I've never witnessed before. The plane was packed, and I mean, I was sitting in my seat in row 13, and people were still coming in, luggage after luggage, and so on. And there was a gentleman about my age just in front of me. And as the sea of people was trying to find their seat and so on, you could tell he was having a very serious panic attack. And he got up, and he opened the overhead baggage compartment, took his luggage, and you look at people around him, and he said, "I'm sorry, I need to leave. I can't. There's too many people. I just can't." And he left. And the people around it kind of took us by surprise. And the first thing that came to mind to me, I hope that Air Canada, when he goes to rebook his flight, shows him the courtesy of recognizing that he did have an event. And I don't witness these often as they happen. I get it in the form of a complaint that's been filed, that somebody's denied a service, somebody's refused an apartment, or somebody doesn't get something in their place of employment. So, and I'm raising it because it's happening, and it will happen more and more because our world is changing. And I just look at New Brunswick. You might have heard it in the news. We've broke 800,000. I know for a lot of you, that's not a lot of people. But for New Brunswick, it's a fair amount. It really changes the socio-demographic of our province. And with that, it creates opportunities, but it also creates challenges. And we're seeing it in our schools. We're seeing it in our hospital. We're certainly seeing it in housing. And we're seeing it in employment. So you'll see a lot of similarities between what Raj was talking about earlier and about the New Brunswick Human Rights Commission. So our commission, our act, was part of that great reform that happened in the 1960s under the Louis Robichaud agenda, where a lot of changes were made to basically make my province, more, bring opportunities to the region. And a big part of it was the creation of our Human Rights Act. The gentleman in the picture sitting down, and I don't know if you can tell, but with a pipe, is Dr. Noel Kinsella. And I would say, and I'm not the one to score points, but he's pretty much the equivalent of your Ronald Gitter here. A scholar, a lawyer, a legislator, a senator, and somebody who instantiated the Human Rights Commission. He was our longest-serving chair of the commission, over 20 years or so. And during that time, he addressed some major issues that the province had, especially for the Black community in the St. John area in terms of housing and access to services. You can also see from, and this is other than Jack Weber, who was the Minister of Labor at the time, this was the first commission member structure. And we see a lot of diversity into this group. There's one person missing, Sarah Wilson, who was from the Big Cove First Nation in New Brunswick. And she's absent for the photo, but she was one of the original members of that commission. The commission is your standard gatekeeper commission. We both have a mandate of compliance and protection of human rights. With the Act came the commission itself. So the commission is a citizens commission. It's composed of two components, the commission members, but also the staff. Now that's where, if you go in our legislation, you will see that the commission is basically the leadership of the commission are the commission members, the appointees by order and council. And that the chair can appoint officers under Section 15 to help in the administration of the commission. That, to my knowledge, has never happened. The commission staff, myself, my staff, we're civil servant. We're hired by the Department of Labor. We're part of the Department of Labor called Post-Secondary Education, Training and Labor. The name has changed over the year, but for all intents and purposes, it's a department that is very much has a labor and a post-secondary culture. And as you see, we're not supposed to advocate, although now, and I'll talk a little bit more about that, it's still part of our legislation. And we will take complaints from the time they're filed all the way to when commission members host a meeting, and there's a determination that they accept our recommendation of what the work that the staff has done, and then it goes to a board of inquiries. In New Brunswick, we don't have a specific independent human rights tribunal. We use the Labor and Employment Board. Over the years, this is our compliance process, our complaint process. And over the years, we've done a lot of changes. I'll give you an example. Initially, there was about 11 people within the commission that would touch a complaint from beginning to end. And you can just imagine, it's already sometimes traumatizing, difficult to file a human rights complaint. If you had this level of bureaucracy to it, we had a lot of complaints that were either abandoned, we ended up in our queues. We had a backlog. We still have a backlog, but I'll talk about that. But it's a lot less than what we used to do. All this to say that within the means that we have, we've done a lot of changes in order to make our compliance process not only more accessible, but more representative of the type of complainants that would file in New Brunswick, keeping into account newcomers, people of different languages, and so on. So we've done a lot of changes in that respect. But you see that the process is very similar than other commissions that you would see. For all intents and purposes, you can see this level of complaint based on the number of complaints and the number of allegations per complaint. The last couple of years, there's been a spike. And as Raj alluded to, a lot of this is related to the pandemic. The Commission has been contacted often over the last 3 years for information, releasing statements, and so on. Of those, that represented about almost 2,400 inquiries that a commission receive, which 80% or so we process. The other 20% are referral that we send to other agencies. It's 284 complaint files, so that's a 20% increase over previous years. We resolved about 20% of those to our mediation process, which is fairly effective considering it's 2 people. And on average, we'll close between 240 and 250 complaints in a year. And that's, if you look, and that's done with the current budget. So for the last 10 years, since 2011-2012 fiscal, our budget has stayed pretty much the same at about $1.25 million a quarter, with a staff of anywhere fluctuating from 9 to 13 people. And I say fluctuating because that's one of our key issues, is to hire and retain our senior people. We bring them in often, investigators, mediators, even legal folks, bring them in from early in their career. They'll stay with us for a while, and then they transition to a higher paying job. We're working on that part to address it. And so in the last couple of years, we've been working on a business case with the department to get additional resources. And this year, in April, we were granted a permanent increase of $500,000 a year, which is quite substantial, but we had to work for it. And with that, we included 5 more investigators, and we were able to reorient. Is my time done?
Go another 4 minutes.
Okay. And with that, we were able to hire, repurpose, if you want, people in our communication, education, and create the advocacy unit. And I'll go to that. So this is our structure currently, with the chair, Claire Roussel-Sullivan, the commission members, and at the bottom, the advocacy unit is a unit that we integrated with our research, communication, and education's function. So now we have 3 people, including a few students on a cyclical basis. But it gives us a lot more capacity to do things. And to do things on the public education side, but also on the advocacy. Because, as the code says under our section 13, for the principle that every person is free and equal in dignity. It's, in our case, it's no longer just about public education. It's about being able to target decision makers, the elected, because those constantly change. So the re-education is ongoing. And to be able to demonstrate why the Commission exists and why it's important in terms of the work that we do and how we reach the people. I'll skip because I really want to get to the end. Okay. Our transformation that we started a few years ago has been based on a framework of change. And that framework, we didn't reinvent the wheel. We based it on the Paris Principle. And we worked in the legal framework and the governance structure that allowed us to put pieces together. Is it a perfect organization? Absolutely not. But we were able to secure additional funding. We have a higher level of operational independence, even though there's still a lot of things that I have to walk to the department to ask for. And we also have a better diversity on our commission board, our commission members. And we also have an organization that is much more adapted to today's challenges and now is able to move forward. And it's much more flexible than the mostly entirely focused an organization on compliance, dealing with complaints coming in and going out. So on that note, I think we'll pick up at the Q&A session later on. Go first. There's a guy.
Thanks, Fred. Thanks very much. Full disclosure, I'm a fan of Ron Gitter, so you need to know that. And I'll tell you something about my background. Besides being the former chief of the Human Rights Commission, I acted for the Human Rights Commission for about 5 years. So I had a lot of interesting cases, including a couple that went to the Supreme Court of Canada. I was a provincial court judge for almost 10 years. And so I have a little different perspective, I think, about how I see the operations of the Commission, because it's time for change. It's time for change. But I want to say a couple of things. You know, you can tell a lot about a new government by their Bill 1, the first piece of legislation they introduced. And in 1972, the first piece of legislation introduced by the then new Conservative government was the Alberta Bill of Rights. The second piece of legislation, Bill 2, was the Individual Rights Protection Act, which is the precursor of the human rights legislation. And a couple of interesting things about those pieces of legislation. First of all, they were declared to be paramount over every other piece of legislation that the government might pass, but also very interestingly, they had preambles to them, which was unusual in 1971. Because preambles are designed to tell us what the act is about. And if you read the preamble to the human rights legislation that we have in Alberta now, it's almost a mirror image of the UN Declaration of Human Rights from 1948. And the interesting thing about that is that that UN Declaration was written in large part by John Humphrey, a lawyer from Edmonton who was working at the United Nations with Eleanor Roosevelt. So those things are important. They're important because they tell us what we should believe in. Now, things are changing. Things are changing, and they're changing dramatically. I don't know what Bill 1 will look like under the new government. I have a few ideas, but I'm not sure what it'll look like. But it will tell you about the tenor of that government. And the human rights legislation is absolutely critical. And in 1971 and 72 was the beginning of what I call the rights revolution. And we need another rights revolution. That's what we really need. Because not only did we get the human rights legislation, but we got the repeal of the Sexual Sterilization Act, which was an abhorrent piece of legislation. And finally, those victims got some compensation later on, too. We also got rid of the Communal Property Act that discriminated against our Hutterite citizens. So there was lots of important things happen then. But one of the most important things that happened was, and if you ever have trouble sleeping, read Hansard. Okay? But I had occasion to read Hansard during the debate on the third reading of the Individual Rights Protection Act. And Ron Dhir was the MLA who was charged with shepherding that legislation through the House. And he was challenged in the debate, and I'm going to paraphrase, but you can find it for yourself if you like. And like I say, if you want to go to sleep, read Hansard. But an opposition MLA by the name of Grant Notley stood up and he said, you can have all the high-sounding language you want, but it looks to me like the Human Rights Commission is underfunded and under-resourced. That was before it even started. Fast forward to 2022, guess what? The Human Rights Commission is underfunded and under-resourced. Now, we can talk about models, and I've got a few models for you because I believe in independence. And that belief in independence came from my time on the courts. Because it's critical for all of us that the courts be independent, right? And there's three criteria to that independence. Independence of tenure, independence of administration, and financial independence. And I know that on our tables there is a petition that says, let's make the Human Rights Commission an office of the Legislative Assembly. Not a bad idea, not a bad idea. But my view is, why don't we take human rights complaints that have to be adjudicated to the civil division of the provincial court? Then there could never be any interference with the adjudication process, ever. ever, because those judges are truly, truly independent. We heard about different models. That might be a direct access model where you simply, like you do with an employment complaint, you file the statement of claim and you go to court and let it be adjudicated. But you need to have the commission. And the reason you need to have the commission is normally you have to have the prima facie test, right? Which on the face of it, is this a good complaint? Is this a good complaint? And I would see having, and Raj talked a little bit about this, about the Ontario model, but having a system where you could screen the complaints, you could have complainant advisors, and you could have respondent advisors. Because you know what? A lot of the people that get caught up in the human rights system are small employers. You know, the first reported human rights case in this province was a case called Weasel Fat versus Denny Shell from Cardston. And Miss Weasel Fat, because she was Indigenous, had to prepay for her gas. Well, now we all have to prepay for our gas. But Denny's might have needed some help as well, right? Because you know what? Most lawyers I know can't afford to hire a lawyer. So if you had an equal sort of division of labor, somebody helping the complainants and somebody helping the respondents, you might have a better process. One of the problems for the Human Rights Commission is the delay. How many people touched that file? I read a decision from the Human Rights Tribunal, and this is not a criticism of the tribunal, it's just a reality. The complaint was filed in 2013. It was adjudicated in 2020. I read another one. Complaint was filed in 2014, adjudicated in 2022. Something seriously wrong with that picture. Something seriously wrong with that picture. What's the old adage? Justice delayed is justice denied. Yeah. So there has to be a better system. And I think that putting the adjudication into the courts, having the commission, because the education component for the commission is extremely important. Extremely important. And one of the things that happened a few years ago was there was a fund that the Human Rights Commission administered, and it could give grants to various community organizations and encourage human rights activity. That fund was eliminated. It was $1 million fund. In the scheme of government, no disrespect, but $1 million is chump change. But for a program like that, it's very, very important. And, you know, that money used to come out of lottery funds. So who cared? Who cared? It's important to have those kinds of initiatives. It's important to be able to take programs to schools, to the community, and so we still need a commission. But I think we can improve the adjudicative process. More resources, absolutely. I can't imagine how you do it, Raj, in a province the size of Ontario with a budget not dissimilar to what Alberta has. I mean, that's amazing what you're doing. And I'll probably step away in a moment, but Raj did say he came from Toronto, the center of the universe. He's also a hockey fan, and Toronto is the only city in the country where the Leafs fall in the spring.
Hello, everyone. Yeah, like my colleagues on this panel, I do want to start by expressing my appreciation to the Dignity Forum for inviting us to be part of this. As some of you may know, I was appointed as the chief of the Alberta Human Rights Commission a little less than a month ago. But when Ron called me and told me the essence of this conference, I promised him right there that I was going to come. Now, I was told I have 15 minutes, and I'm going to try to keep to those 15 minutes. And I had specific instructions to speak to the structure, the strengths, the limitations, and the funding of the Alberta Human Rights Commission. Now, our commission is a statutorily created commission, and it has a simple mandate, a simple but complicated mandate, which is to foster equality and reduce discrimination in Alberta. And by way of organizational structure, our commission has 3 distinct and, in fact, independent units. The Office of the Chief of the Commission and Tribunals. It is under that office that you have the Human Rights Tribunal, the Communication, Education, and Engagement Unit, and the Complaint Management Unit. I'm just going to briefly tell you what each of these units does. Now, for the Communications, Education, and Engagement Unit, their primary role is to educate the public, and they do so in a variety of ways, by way of engaging stakeholders and also by partnering with organizations, human rights organizations, including ethnic community organizations, with a view to identifying the issues, the human rights issues that are prevalent in those communities, and then try to foster a cordial relationship and come to an agreement as to how best to achieve the reduction of discrimination. They also oversee our education programs. Indeed, they run seminars, some of which are online, for both employees and employers. And they also deal with information technology and data analysis, because part of the things we do at the Commission is to analyze where human rights complaints are coming from. What is involved in these human rights complaints? And that enables us to focus on certain specific areas, given the limited resources that we have. Then the second unit is the Complaint Management Unit. This is a unit that, so to speak, is the first point of contact for members of the public who may feel that they are being discriminated. So this unit takes questions from members of the public. Indeed, am I in the right place? I can't see it. No. One back? Okay. Indeed, 2020 to 2021, this unit received 8,014 calls. And all of these were dealt with, in my view, successfully by that unit. They also receive complaints, process the complaint, and attempt through conciliation to settle complaints, long before a complaint is referred to the tribunal. The director of this unit has the statutory power to recommend to the tribunal that a case should be heard. They also have the power to dismiss a complaint where they believe that there's really no merit to the complaint. But they do so on the basis of documented evidence. And lastly, you have the Office of the Chief of the Commission and Tribunals. That's where you have, as I said, the tribunal. The tribunal is independent. It's an independent adjudicative arm of the Commission. There's really no contact. There's hardly any contact. I was a member of the tribunal before I was appointed as chief. And I had no contact whatsoever with the complaints unit or the communications unit. So we tried to structure the 3 units so that at least there's some semblance of independence. So at the tribunal, we do things such as tribunal dispute resolutions. So before a complaint goes to a hearing, we oblige the parties with an opportunity to come before a member of the tribunal with a view to settling the issue. It is only when that issue is not settled that it ultimately goes to the tribunal for a hearing. And of course, as you know, the tribunal hears complaints and renders decisions, written decisions, which are publicly available on CANLI. Now, just by way of clarification, I know my colleague mentioned that one of the things that he sees at the Commission is delay. I would urge all of you to go to CANLI. You will see the complaint numbers. Right now, our turnover rate, it's about maximum of 2 years. I wrote a decision last week over a complaint that was filed in late 2020. So that's how efficient we've become. You need to come close to us in order for you to know some of the things we do. We are not as inefficient as you may think. And I dare say, some of my colleagues over there will bear me out. I dare say that over time, we've used the resources we have to such a degree that, in my own view, we have become exceedingly efficient. Now, in terms of strengths, one of the things that I find particularly interesting in our commission is the degree to which it is accessible to members of the public. Now, we have bylaws where we specifically state that although we do hearings, these hearings are more or less informal. Informal in the sense that we do not follow the rules of a conventional court. And the reason we do that is to allow members of the public who are not legal experts to participate meaningfully in the resolution of their complaint. So we do away as much as we can with legal jargons, with legal dogmas. We want to focus on the facts. And we are permitted, under our rules, not to follow specific rules of evidence. And that way, our tribunal is a lot more accessible than it would otherwise have been if we were following technical issues. Indeed, because of the accessible nature of our tribunal and our commission, in 2020-2021, a total of 1,334 complaints were resolved. Now, the resolution of these complaints was achieved through various means: conciliation, tribunal-directed resolution, settlement between parties, aided, of course, by the commission, as well as hearing decisions rendered by way of hearings. Excuse me, I can't see. Where am I? Maybe. Yeah, thank you. Okay, strength. So, as part of our strength, we think we are one of the most diverse tribunals in this country, if not the most diverse. I urge you to go to our website and see the names. Not until 2 years ago, less than 2 years ago, someone who looked like me never sat on the Alberta Human Rights Tribunal. And here I stand before you today as a person of color who heads not just the tribunal, but the commission. So as much as we want to see a whole lot that we do not like within the commission, there's a great deal that is going on in the commission that is absolutely commendable. Indeed, it is an example to other commissions. Why do I say this? For a commission, a Human Rights Commission, to properly perform its role it must, and I'm using that word, must reflect the community that it serves. It must reflect the community that it serves. The decision makers at the tribunal must reflect the ethnic makeup, the cultural makeup of the society that it serves. And I think we here at the Alberta Human Rights Commission, we've achieved that. It is something to be applauded. And in terms of funding, you know, I was a little surprised when Mr. D mentioned 5 million. We get more than that. We do. I'm not saying we have enough, but we get more than that. Does it mean we're not asking for more? No, we do. We're going to ask for more. But as I speak, we get more than that. Now, one of the things that limits our ability to properly advocate and properly educate people about human rights is the structure. It's the statutory structure, statutory nature of our commission. Our commission is systems-based. It is complaints-based, I should say. That is to say, if an individual feels that he or she or they have been discriminated against, they file a complaint. And as somebody observed, I think it was my colleague who made the observation, that as a group, if you are discriminated against, under our statute, you do not have the standing to file a complaint. So to that extent, that is a limitation. We lack, as a commission, the authority or the mandate to proactively investigate human rights. Now, if we had such an authority, that would of course mean that we would need more resources, a lot more resources than we currently have. And we do not also have, because of the nature, the statutory nature of our commission, we do not also have the capacity to address systemic discrimination or institutional racism. Now, in terms of independence, we all have different concepts of independence. I have studied human rights commissions across the globe. No one commission can truly be said to be independent. I'm a realist. I do my things based on realism. No commission can truly be said to be independent. The only way a commission can be truly independent is when the commission can raise its own money. Nobody somewhere gets to dictate how much you get. But to the extent that we as commissions rely on the government to provide us money, we cannot truly be said to be independent. Now, in our own case, I, as chief of the commission, am statutorily obliged to report to the Minister of Justice. Now, personally speaking, for me, that's not a problem. It is not a problem. I'm not saying it cannot be a problem at all. It could be. But personally speaking, it is not a problem. It's not a problem because since I've been at the commission and since I've become the chief of the commission, no one in government, not the minister, not any other minister, not the Minister of Justice, not anybody in his office or our office has called me to tell me what to do. I do things that I think are right in accordance with the mandate of the commission. And I simply inform the minister, this is what I've done. The only time I ask the minister for authorization is when I'm asking for money. Other than that, there's nothing else. I do things in consultation with my colleagues. I do things that I think are right. My 15 minutes. Okay. You are being generous. Okay. I also want to say that at our commission, in terms of independence or autonomy, we are not faced with any restrictions, influences, or pressure from outside sources, be they government or private individuals. I know there's a popular case that happened decades ago where apparently there was an attempt or there was real exertion of influence on the commission, but that's not so anymore. We render our decisions without anyone telling us what to do. Now, finally, I want to say this. Is there any one model that fits all? No. Every province, every state, every jurisdiction has to determine for itself the model that best fits its unique circumstances. Indeed, one of the primary reasons why I readily accepted to be part of this conference today was because I wanted to learn, particularly from the Ontario model. I wanted to learn. The more we learn, the more we know things, the more we improve the way we do things. Now, there is a petition that, when I came in today, was the first thing that struck me. There's a petition on your tables. Some of you may have seen it. The second paragraph of that petition, I would like to quickly say something about that paragraph. If you read that paragraph, it presupposes two things: that the Alberta Human Rights Commission is not functioning properly. That's not so. The second thing that may occur to you when you read that paragraph is that currently the Alberta Human Rights Commission is not able to appropriately adjudicate complaints. Again, that's not so. Are we perfect? No. Is there room for improvement? Yes. That's why I'm here. Thank you all.
How much time? Okay, I think we've heard quite a diversity of opinion about human rights commissions. We have about 20 minutes for Q&A. You've heard from Ontario, where they have a model of three different types of structure, three different modes within their model of structure. And the defense of that was that it's far more efficient, that you can direct funding to these different functions, and that the commission can do its work more efficiently. We heard from the New Brunswick Human Rights Commission experience that it's time for change, that human rights commissions have languished in the problems they all experience of delays and lack of access, and that they have targeted different areas within the Human Rights Commission for more attention. And I know I'm being very, very general here. And then we heard from Judge Phillips that he also thinks it's time for change, but he would see a model where you would divert human rights cases into the courts to ensure independence. And then we heard from the Chief Commissioner here in Alberta that things are okay in Alberta by and large. They are independent. They are getting things done in an efficient manner, and that there's no real concern that needs to be immediately addressed. So I'm sure there's a lot of questions that you may have about these different presentations. So please, the floor is open for questions. Yes, over here.
My question is, how can the Human Rights Commissions respond to this massive, massive problem, especially when those experiencing homelessness experience compounding and layer upon layer of both systemic and individual human rights issues? These are the people who are survivors of the residential school system. They're dealing with mental illness and addiction. They are newcomers to Canada, and they don't have access to phones to call you or a computer to download the form. So there's very simple and very complex issues that human rights commissions need to respond to.
Okay, Chief Commissioner, do you want to start with that one? Just turn it on. Yeah, it's on. Yeah.
Hello? No, it's not.
There's a little switch right by the screen.
Okay. Oh, good. Hello?
Okay,
Good. Yeah. That's a good question, but I'm not really in a position to answer the question. And here's why. It borders on the limitation that I spoke to while I made my presentation. The Alberta Human Rights Act does not empower the Commission to proactively look into human rights issues. Our system is entirely based on complaints. So to the extent that a complaint has not been lodged with our commission, there's really nothing, legally speaking, that we can do about it.
Okay, simple.
Your question is more suited to the Ontario model, if I may put it that way. Or do you?
Okay, I think
To address it.
this begs the question of models. As you
Yes.
see, this is a very, very good example of how a model can prohibit human rights resolutions. Yes, please, go ahead, Raj.
So in Ontario, the Ontario Human Rights Code, like the Alberta Individual Rights Protection Act, does not include a ground of social condition expressly. So to get at poverty, to get at homelessness, we need to rely on the intersection of other grounds and look at adverse effects on vulnerable communities. So the way that the Ontario Commission has looked at some of these issues is in three ways. The first is that we have a poverty advisory group that brings together people with lived experience, experts, community organizations to work with us on strategies to try to address some of the issues that arise as a result of the current conditions of homelessness that we're seeing. Second, we are currently engaged in a consultation with vulnerable communities and social service providers that focuses on poverty, in particular the intersections of poverty. So that includes mental health, addictions, as well as Indigenous, Black, and racialized communities, among others. And then the third thing is that we have made submissions to the government as part of their poverty reduction strategy, urging the government to take a human rights-based approach as it's looking at trying to implement that strategy. So that's how we've tackled that issue. I wouldn't say in terms of outcomes, we're just scratching the surface. Like there's so much more work to be done, but we hope that it's a starting point.
Okay. Marc-Alain, did you want to try to answer that one as well?
Yeah, and being the non-lawyer, I'm probably going to get in trouble, but I think that we created this dichotomy because on the one hand we say that housing is a human right, and on the other side, when someone calls on us to help them with their situation, and we're saying, well, you need to file a complaint, but it's not really discrimination. I think the bigger issue is that, and we're seeing it now, and I think it's across the country, is that we're using housing as a wealth generator without a lot of consideration for the fact that housing needs to be a human right. You need to have a roof over your head. And as long as we keep going down that path and we let things happen for, investments and renovations and all these things, it's only going to get worse. And there's going to be a segment of our population that's going to suffer. Not the people in this room, more than likely, because we can afford housing, or some form of housing. Maybe not what we want, but we can still afford them. But there's going to be a growing portion of our population that won't be able to do.
Okay, and Judge Philp.
Thank you. Kate, as I heard your question, it was really about how do you physically access the Human Rights Commission? And that's a tough question. And full disclosure, I sit on the board of Boyle Street Community Services, so I know exactly what you're talking about. And one of the things, it's difficult to say to somebody, well, all you got to do is go to the 6th floor of the Standard Life building and file a complaint. And what you're suggesting, I think, is some community outreach maybe where human rights intake officers attend at social agencies or things like that. Is that what I'm hearing you say? Yeah. And I think it could be done. I think it could be done. It's just a resource issue, but yeah, it's pretty hard to file a complaint if you can't get to the place where you have to file the complaint.
Okay, thank you very much for that great question, Kate. That sort of really brought into focus a lot of what we're talking about here. Does anybody else have another question? Yes, please.
Thank you. Okay, so my question is around, similar into the vein that the question was just asked around, but access and accountability. So for all of you on panel, but especially around in Alberta, when we look at the number of settlements that were achieved, I think it was just over 1,000, and that's a pretty good statistic to say that those complaints that were put through on an individual basis were addressed in some way. My question is, would that success be defined in the same way by those who issued the complaint and the communities that they represent? And with that, is there a pathway or a means for communities and individuals to disclose their experiences of success with that settlement, and how can that be accessible and therefore accountable to the larger public for us to understand how human rights commissions work within Alberta, but of course, coast to coast?
Okay. Ivar, do you want to handle that one? Sure, go ahead.
Yeah, thank you so much for your question. As I mentioned in the course of my presentation, the complaints that we resolved between 2020 and 2021 were resolved through a variety of means, including tribunal-directed resolutions, which involves a commissioner, a tribunal member, and the two parties to the complaint. And sometimes it also involves the director, because when the director has carriage of a complaint, the director is represented by counsel. Now, in terms of whether people who are involved in these complaints will see the outcome as success, that's one of the problems we have in the legal world. Not just in terms of commissions, but also in relation to courts, generally speaking. When you go to court, there are two likelihoods. One party wins the case, the other loses the case. For the party who wins, he or she is successful. The party who loses thinks that he or she is either unsuccessful or has been I don't know what word will I use now, has been messed up by the system. It's the same thing for commissions. Now, here's the thing. If the commission resolves a complaint, there's room to ask for judicial review. So what we do is not the end of the story. So any party or complainant or respondent who is aggrieved, who is dissatisfied with the outcome, they can always ask for judicial review. That is in the case of a hearing and a written decision issued by the tribunal. Now, in terms of dispute resolution methods, there's no way the complaint can be resolved unless both sides, the complainant and the respondent, agree. So if the issue is resolved through dispute resolution, it is successful for both parties because it is their consent. And sometimes complaints do not even get to the tribunal because when they are filed with the complaint management unit, the director, one of the things they do in that unit is conciliation. a complaint could be settled through conciliation. Again, in order for you to have conciliation, both parties must agree. So from the perspective of those parties who are involved in conciliation or tribunal-directed resolution, the case is successful. It's only when you have a hearing and then there's a pronouncement, a quasi-judicial pronouncement by a member of the tribunal, that one party wins the case and the other loses the case. That is when you have the issue of dissatisfaction. Now, the second question you ask is disclosure of these settlements so that members of the public will know that some parties or all of the parties are successful. Now, that's a little bit complicated, depending on how the complaint was resolved. If the complaint was resolved through a hearing, then there's public disclosure. As I mentioned in the course of my presentation, simply go to CANLI. You have an idea what CANLI is? It's a publicly available database for cases and tribunal decisions. If you go to CANLI, you will see all of the decisions rendered by all tribunals in Canada, including our own tribunal. Last year alone, we had more than 100. We had more than 100 written decisions that are now publicly available on CANLI. Now, if a complaint is settled by way of tribunal-directed resolution, the parties would swear to confidentiality. And now, why do we have confidentiality? It is to encourage the parties to settle. In fact, that is one of the reasons why we've achieved the kind of settlement rates that we have achieved over time. The parties would only want to settle if they know that whatever it is they agree on will be confidential. So they sign their own agreement. They draw up their own agreement. We do not draw up an agreement for the parties. They would on their own draw it up. But they will make the agreement in the presence of at least one commissioner.
Okay. Do you want to try answering that question as well, Raj? It's an interesting question because the definition of success, I think that's what you're getting at.
Yeah.
In an adversarial system, is there ever any success in an adversarial system, or are there other methods of resolving these kind of matters? Raj, do you want to tackle that?
I obviously I won't speak about this in the Alberta context because I can't. I can only speak to it in the Ontario context. And I really appreciate your question for a few reasons. First of all, the question recognizes the fact that in our human rights system, approximately close to 90% of the people that engage the system, claimants, are unrepresented. The other reason why I think your question is really important is because it highlights an important distinction that I want to make between outputs and outcomes. And I think that when you're talking about satisfaction or success with the system, to me, there are a lot of factors that go into that, not just the bottom line. Did you get a settlement or not? So those factors for an unrepresented claimant could be, how much delay? How long did it take to get to that endpoint from the time that they first brought their issues into the human rights system? It could be, were they heard? Did they feel that their issues were dealt with in an adequate way by the actors within the system? And thirdly, was there a substantive outcome to how was the power imbalance addressed, in the process? Those are all things that I think are important to assess. And I think the last reason why I think it's really important is it takes me to one of the opportunities for improvement that I did want to speak about earlier, which is I think that human rights commissions need to adopt modern regulator principles around, including things like performance measurement. And I think that, for a long time, including in the Ontario system, we would just track effectiveness and success by things like how many complaints were resolved, how many complaints were filed, how long, what was the wait time from start to finish. But I think that, you do really want to get at more qualitative information about individual experiences. And The last point that I'll say is that I know that in BC, shortly after they introduced the direct access system in their province, they did survey claimants. And I believe they did that early on in Ontario as well, about a decade ago. And, there was a high satisfaction response, in part because of these very things, that we're talking about, all these things that define success. So I do think it's an important thing to look at more closely.
Mm-hmm. Thank you. Marc-Alain? No? And Judge Phillips, did you want to weigh in on this one?
I'd just say this, that, and I think what you were after is, can you use a settlement as an illustration of how to solve a human rights complaint, right? And of course, settlements usually have words like this. This is a compromise of a doubtful claim. The respondent admits no liability, but they'll pay money, right? It's kind of like the Prince Andrew settlements, right?
Yeah. Well, and it also confronts the bigger question, which is, do these processes reduce the amount of racism and discrimination in the society, or are we just focused on a individual complaint? Okay, any other questions? Those are wonderful questions. Really hit the mark. Well, we're right on schedule, I believe. So thank you ever so much for this wonderful panel and all of the diverse views that we've heard about human rights commissions. And I'm sure you're drawing your own conclusions and looking at the petition and evaluating it in that light. So thank you very much.